Now, as a new bond process in Shelby County promises to crack down on the revolving door at 201 Poplar.
Yeah, there's been a growing concern from one criminal justice reform group that this could skew too much in the favor of law enforcement. This all comes after last night's announcement from the Shelby County DA's office. Steve Mulroy says from now on, law enforcement will provide a lot more information to judicial commissioners to help them make decisions when it comes to setting bond amounts.
This includes past information of evidence of flight, evasion, violence, as well as any previous crimes or anything else deemed to be relevant information. Stephen Reels joins us with the reaction to this process. Now, Stephen, this seemed to be Shelby County DA Steve Mulroy's attempt to improve the highly criticized bond process. Where's the concern come in?
Well, Pepper, while Mulroy says this would help with fairness and accountability when setting a bond, Just City Board Chairman Alexander Wharton worries that this could actually bring past allegations into the bond process and put a defendant in an unfair situation.
Those may be characteristics, but some of those things may not even be relevant.
New concern Friday from criminal justice reform advocates like Alexander Wharton, as Shelby County District Attorney Steve Mulroy unveils a new way to give judicial commissioners more information about a person's past criminal activities before the bond is set.
We should have full information about criminal histories.
Shelby County's bond standards have long been under fire from people like State Senator Brent Taylor, who said it often felt like people commit crimes while out on bond for other crimes.
Judge Anderson gives out get out of jail free cards like a daycare center gives out germs.
While Wharton agrees more information is better for commissioners, this process would put more power behind law enforcement's bond recommendation, especially if a person's past criminal allegations are brought into the equation, even if there weren't any charges.
You can't have it so slanted to where you obliviate the consideration of the other factors that also have just as much weight.
Which is why Wharton would like to see an additional step in place and give people the chance to argue the data provided to the commissioners.
Do it where the defendant and his or her attorney has an opportunity to cross-examine that officer who wishes to bring that information in.
And Richard, Pepper, at the same time, Wharton says this has to work both ways and let prosecutors find a way to cross-examine the information a defense might actually be bringing to the commissioner to prove someone is a good person.
Well, Stephen, like you mentioned earlier, Brent Taylor has been one of the more outspoken critics when it comes to the previous bond process. What's he got to say about these changes?
Well, Richard, I did get the chance to email the state senator, and he said he is all for getting the judges and judicial commissioner as much information as possible to help them determine and keep public safety a top priority. So really, at least this seems to be something both Mulroy and his opponents can agree on for once.
All right, Stephen, thank you.